welcome to Law and Democracy, a podcast of the election law program at The Ohio State University. I am Steve Huffner, and I'm the Deputy Director of the election law program here at OSU, and I'm delighted that today, as part of our podcast, I'm joined by Ned Foley, who is the director of our program, but visiting at Princeton this year, and Tony Goggin, who is the Kern family chair in law at Drake University, but visiting with us here at Ohio State this year, and Terry Enns, a senior fellow of the election law program at Ohio State. Nice to see you all today. I know that things continue to be rapidly developing on the legal front as it pertains to the 2024 election. And so what shall we talk about first today, Tony?
Well, Steve, our first topic is mail-in ballots, which have really emerged as a huge part of modern American election campaigns. Just a little background information. In 2016, 21% of voters mailed in their ballots. In 2020, 43% of voters cast their ballots by mail. And in 2024, comparable numbers or comparable percentages are expected. So our topic, or our first question is, what are the special challenges that mail pose for election administration, and for the what potential legal controversies are unique to mail-in ballots?
And I'll just offer one tangent about all this, which is, the 2020 increase in mail-in voting was driven largely by states' efforts to respond to COVID and to provide voters with an alternative way of voting that didn't require them to congregate in close contact with other people. But of course, many voters discovered that they liked the mail-in option. It's still a little early, really, at least for me, to know what we will experience this year in terms of the volume and whether there's a bit of a pullback from 2020 that was COVID related or not. But it does certainly seem that mail-in voting as a significant portion of the way votes are cast is here to stay.
Well,
Yeah, no question.
There was a New York Times article in the last week or so that pointed out what folks in the field have known for a while, but has not been as much in public consciousness, I don't think, is that through just ordinary human inadvertence, a significant percentage of absentee ballots end up not getting counted because it's just a more complicated process of filling out an absentee ballot envelope according to the various rules in the states, and then it's got to get through the mail and it's got to arrive on time. And so while there's a certain convenience element to being able to vote at home, as some people like to call it, and it may be, frankly, in terms of volume, again, we don't know, as Steve says, what's it going to be, but I've seen many stories saying the Republicans are going to use absentee voting at higher rates than they did in 2020. So that could actually increase the volume potentially if the Democrats who used it in the past liked it, and now Republicans are getting on board. It may not dip. In any event, I worry about rejected absentee ballots because voters obviously are casting their ballots in the hope that they get counted, and it's unfortunate when they don't.
Just one more aside on the increased volume. I think states have also been slowly moving away from requiring a reason to use an absentee ballot. I mean, it used to be that you had to say you were going to be in the hospital or out of town or whatever. And, especially post 2020, we just don't see a lot of that anymore. So more people are eligible to cast them than in decades past.
Yeah, I think that's a really important point, Terry, that when viewed in historical context, there are more opportunities to vote today than really at any previous time, even when there are controversies over how long the early voting period is or how long the period for in-person early voting is. American voters in the 2020s have many more days in which they can participate in the election than was the case even in the 1990s.
It's worth noting briefly that in most states, you really have three ways to participate in an election. This is not true everywhere, but in most states, you can vote either in the traditional way on election day by going to your polling place, or you can vote early in person by going to an early voting location as established in your jurisdiction, or you can vote by mailing in a ballot. And it's the mail-in ballots that are the set of ballots that Ned was describing as most vulnerable to loss or some voter failure that means they're not counted. And Ned, you had said that there's a significant portion of those mail-in ballots that get lost in some fashion or other. And I thought it might be worth just unpacking that a little bit. I mean, one person's significant number is another person's small number, but what really matters is that the proportion of lost mail-in ballots can often be larger than a close margin of victory. It's not that, 30% of the mail-in ballots are going lost. It may still be just a percent of the total absentee ballots that are cast that end up not getting counted or not even getting received. But in a race that's a half a point or a quarter of a point between the winner and the loser of a particular contest, those lost mail-in ballots could have been determinative. And that lost ballot rate, even though in some sense it's still just a percent, maybe, I'm just using a sort of ballpark figure, is much higher than the rate of lost votes when you vote in person or when you go to your polling place on election day or go in person before election day.
On that point, Steve, the number was 34,000 rejected ballots in Pennsylvania in 2020. So it was a significant number.
And what was the percentage? Do you remember what that is as a percentage?
According to the New York Times, 2 million voters in Pennsylvania cast mail-in ballots, and it was more than twice that. Over 4 million people voted overall in Pennsylvania, but 34,000 out of 2 million mail-in ballots were rejected.
And I think it's important to make sure that, Steve, when you say lost, you don't mean that the mail carriers lost them. You mean that the votes themselves were not counted for one reason or another. I just wanted to be sure that we're not blaming the Postal Service for all of it.
Right. It's an inclusive term that is trying to capture the number of people who requested an absentee ballot and thought they voted an absentee ballot whose vote doesn't get into the count.
Yeah. And part of what Steve said is one point I'd like to stress, which is if you go to a polling place in person, whether it's your local precinct on election day or it's one of these early vote centers that Steve mentioned, the poll workers there can help a voter who, misses a step in the process because you sign the poll book, they're supposed to help you there. And also if they make a mistake, it's usually easier to retrieve a vote if the poll worker committed an error. And they're supposed to give you a provisional ballot, even if they don't give you a regular ballot. And nobody should go to a polling place thinking that they're eligible to vote and walk away empty-handed. If the poll worker won't let you vote and you think you're really in the right place and eligible to vote, you should vote a provisional ballot. Because if it's poll worker error, that can come up in your defense. But since we're talking about absentee ballots, there's no poll worker sitting next to you when you fill out the envelope, and so nobody can help you rectify that mistake. And as Steve says, it may be a relatively small percentage of voters, although it does vary state by state. I haven't looked at the numbers in a little while, but sometimes it can be high as 5%, I think, of absentee ballots being disqualified for one reason or the other. And often it's much lower than that, as Steve said. But the key point is it worth litigating over in a close election? And history tells us that the most of genuinely disputed elections in the past few decades have been, other than Bush versus Gore, which also had some absentee ballots at issue. That's the Florida 2000 presidential race, which had a lot of different problems, including absentee ballot problems. But I'm thinking of the US Senate race in Minnesota in 2008 between Norm Coleman and the then comedian Al Franken, who ended up winning that race and becoming senator. That was all fought over absentee ballots and the disqualification under state law of absentee ballots and whether it was right to disqualify them or not. Washington State in 2004 had a governor's race that was ended up, I think, being a statewide margin of 127, so extraordinarily close. But there were thousands of absentee ballots that were fought over as part of that fight. So, I do worry that if we have numbers of the kind that Tony was talking about, where Pennsylvania, for example, disqualifies over 30,000 absentee ballots. Now, the margin in 2020 was much larger than that. I think it was 80,000 Biden won Pennsylvania by, if memory serves. But if this year, if Pennsylvania is more like that 10,000 margin that existed in Arizona and Wisconsin and Georgia back in 2020, and you've got a 10,000 margin and over 30,000 disqualified absentee ballots, I'm not saying that the election's going to get overturned, but I'm just saying that that's going to give lawyers something to fight about for several weeks at least.
And Pennsylvania gives county officials wide discretion to decide how they process absentee ballots. And so there isn't a clear guide for how to help voters correct a ballot that they submit that has a flaw. I would also add, in the New York Times article I made reference to before, which is a Michael Wines article, who's one of the leading national reporters covering election law. He points out that there's a study done recently in Florida that found, even though Florida has a statewide standard for how to alert voters when their mail ballots are defective, there's still great variation from county to county in how that law is actually applied, at least in terms of what percentage of voters actually are informed that their ballot was defective. In this study that the New York Times describes, the voter in Pinellas County, which is where St. Petersburg is located, was 30% more likely to fix a ballot than a demographically identical voter in Fort Myers, which is only about 100 miles away. That's in the same state.
Now, you can imagine that a state might require that election officials make a reasonable effort to notify voters who've sent in an absentee ballot that is in some way defective and can't yet be counted, of the fact that it's not countable yet. But what a given election office does in making that effort to contact the voter could vary quite a bit. How many calls they make, and
Yeah, again, this is another one of the elements of state by state variation. Different states have different rules. And then, of course, even if they're rules, they get followed in different ways by different localities, given the decentralization of election administration. I worry that this, potentially could lead to an equal protection issue of the kind that proved dispositive, an outcome determinative back in 2000 in Bush versus Gore. As many people may remember, the constitutional principle on which the U.S. Supreme Court relied in that case that really effectively settled that election was an equal protection principle having to do with local variation on the treatment of equivalent ballots. Now, it wasn't mail ballots, it was so-called hanging chads or dimple chads, which is a very arcane term that we probably would like to forget and not have to our memories resurrected. And for our purposes today, you don't need to know how dimple chads differed from pregnant chads, different from hanging chads. The point that the Supreme Court said is if you've got two identical ballots in the state of Florida, they've got to be counted the same way. They can't be differentially treated when the two pieces of paper look the same. And if that's federal constitutional principle, it applies to any ballots cast in an election. And so if two absentee ballots in the state of Pennsylvania are defective or deficient in exactly the same way, missing the exact same kind of date or missing the same zip code or whatever it is, you would think that the same equal protection principle announced in Bush versus Gore would say they have to be treated the same way in the same election in the same state. But this issue did surface in 2020 in Pennsylvania in a context when it was not outcome determinative. There was a lawsuit, I think, by, if not the Trump campaign, one of their allies, arguing that this local variation that Tony is talking about in Pennsylvania with respect to giving voters the opportunity to cure defects was an equal protection violation. And the remedy that Trump and his allies was seeking, which was to invalidate the entire election in the state, was never going to be given by the judiciary. And so the court could have and did reject the case on that basis alone. But the court went out, I don't know, the court added as another reason for rejecting the lawsuit was its belief that the equal protection principle didn't apply in that context. And that's frankly a head scratcher to me. I mean, I certainly understood and agreed with the notion that the Pennsylvania election 2020 shouldn't be overturned. There were just a few thousand ballots affected by this particular cure issue at the time. It wasn't all 34,000 ballots that were rejected. And even if it was all 34, it wouldn't have made a difference to the outcome. But I'm not sure that the court got the equal protection analysis correct, or if the U.S. Supreme Court would agree with it if that became really important this time around. I don't know, what do the rest of you think about the application of the concept of equal protection to the kind of local variation in treating absentee ballots that Tony's talking about?
Well, I'm generally in agreement with you, Ned, that it seems on its face like it's exactly the kind of variation that the U.S. Supreme Court was unwilling to tolerate in the Bush versus Gore case. At the same time, we've continued to see a variety of local variations that have gone that we've tolerated, and so it's hard to be absolutely sure just which way it would go.
What, to shift gears only slightly within the same topic, and I hope we don't get ourselves into this difficult situation, but what if Harris wins the national popular vote, which is legally meaningless, but is often a talking point of moral vindication and sense of national popularity. And Pennsylvania ends up being the pivotal state, and Trump wins Pennsylvania, but there are more of these uncounted absentee ballots than the margin in Pennsylvania. Do you think one of the goals of reforming the system after 2020 was to reinforce the notion that our elections get decided pursuant to the rule of law, whether you like the legal rules or not. And so, we have an electoral college, whether you like it or not. That's what matters, not the national popular vote. We have rules about absentee ballots, whether you like them or not, though we have to follow the rules. But, I can imagine Harris supporters being unhappy if, their candidate has won the national popular vote for all that, that does her. And there's a pile of ballots out there cast by voters who themselves are eligible to vote. This is a key point. These are not non-citizens. These are not unregistered voters. These are voters who, there's nothing wrong with the voters themselves, and they tried to participate in the civic process of democracy in good faith, but they inadvertently made a mistake that and therefore, will be disenfranchised. I think it correctly is the correct use of that term. Um, I, I mean, maybe the answer is people will kind of, kvetch about it and grumble about it, but ultimately accept the result because that's what the law requires. I just worry we're in a climate where the stakes are so high, there'll be an effort to try to undo a result, even if it is the legally correct result. Again, normally we've seen Trump try to do that in the past, and I'm not predicting that that's what's going to happen. I just worry if there's all these ballots that are out there that aren't counted, people are going to be upset about that.
I also suspect, Ned, that we're going to see litigation even before we know what the outcome is. Once it becomes clear that this could be dispositive in terms of who wins the individual state. And I think there are two distinguishing factors from Bush v. Gore that actually would weigh in favor of applying the equal, or at least give a court more reason to apply an equal protection standard to adjudicating different approaches from county A to county B. And that is, number one, I do think just in general, litigation will occur on a much faster track in 2024. The Electoral Count Reform Act itself has provisions to provide for a fast track, at least in federal court. And secondly, in Bush v. Gore, it has always struck me that in the back of the justices' minds, I think, was the understanding that because so many of the disputes turned on very subjective interpretations of the intent of the voter because of flaws in Florida's ballot design in places like West Palm Beach, that the justices were concerned there might not be an outcome. Plus, of course, the overriding issue, at least in the view of the court, was they were running out of time. I think though both of those issues can be avoided in 2024 because I think the litigation will be fast-tracked, A, and B, I think ballot design is so markedly improved in 2024 than in 2020. Now, this might be famous last words, but I am cautiously optimistic that there won't be a dispute that would require a highly subjective interpretation by county level election officials. Instead, it's just a straight up legal issue of, are these ballots going to count or are they not? And I think that would encourage a court to weigh in because that is a judicially manageable standard then that can be applied in a way that West Palm Beach in 2000 didn't really offer because of the fatally flawed ballot design. But again, I might be overly optimistic.
The place that I worry about your optimism, Tony, is maybe in the signature matching realm, because that's the place where there's quite a bit of discretion remaining for untrained people to say, what's in my poll book that was signed 25 years ago does not match what came in on this week's ballot. And I do worry about that. And to me, it seems like if the voter did everything right and their vote is ascertainable, unlike some of the hanging and pregnant and dimpled chads, that then the burden should be on the election workers if they're not going to count it. And that would have to do with late arriving and what the deadlines for that are and those things. I just think if the voter tried their best and did everything right, and by that I mean they did everything right, but the mail is what's holding it up, then I just find it really hard to swallow that they could be disenfranchised in that circumstance where they dropped it in the mail before the due date. But that's hopefully a very, very small percentage. But the handwriting match really concerns me for discretion.
Yeah, and I think, Terry, that's an important point because if the absentee ballot envelope has a signature on it, then presumably the voter has signed it, maybe not to the election worker's satisfaction, but they've complied with the legal requirement. And again, assuming that it's an honest ballot. It's not a fraud or forged signature or anything like that. It's just the election worker rejected it. There, I think the chances of litigating to the acceptance of that ballot are decent both under state law and potentially federal law. Again, it would be a tumultuous time. I mean, only a slit, again, varies state by state, but it tends to be ballots rejected for signature mismatches are a smaller component of rejected absentee ballots than missing a required date, for example, or missing. Sometimes some states still require witnesses, I think, and they are often missing. So,
Just a few.
yeah, just a few. There's different categories. Uh, to Tony's point on timing, I sure hope, Tony, you're right, and that I do think there's a goal to be quick this year in processing any issues involving absentee ballots or anything else, although Pennsylvania didn't change the law that they could have to accelerate the process even more so. And that worries me. You alluded to the federal deadline in the new Electoral Count Reform Act, and essentially everything's got to get wrapped up by December 16th. I think we've discussed that on our podcast previously a little bit. And uh, you know, it ought to be possible to litigate things, I referenced the Minnesota 2008 U.S. Senate race, and on the date that the Electoral College met that year, because it was a presidential election, the U.S. Senate race was still in the middle of a recount. And that's, they probably could have speeded it up a little bit, but their litigation over absentee ballots lasted until June 30th, 2009. And that's just not an option, right? I mean, this all has to get wrapped up by December 16th under the statute, the day before the electors meet. And so um, if there are issues involving absentee ballots in Pennsylvania or anywhere else, I hope the courts are ready to handle this in an especially expedited way.
In a way, I think 2020 is very helpful, both for election administrators and for the courts, because they've been here before. 4 years ago, they were. And although there are, of course, some new judges and some new election administrators, there's much greater institutional familiarity with election controversies than there was, I think, certainly before 2020, even though, Ned, as you have written in your book, Ballot Battles, we've had election controversies from day one of our democracy, but they're certainly more front and center in the public consciousness today because of the closeness of our elections. So I am hopeful that the judiciary and election administrators are even better prepared in 2024 for an extremely close election than they were in 2020. And they did an exceptionally good job and overall in 2020. So that's another reason, I think, for a level of confidence going into November 5.
And
Yeah.
Tony, it's long been the case that we've also had a decent amount of pre-election litigation, but maybe we're seeing even more this year than in previous years. And to the extent we see that reduce the amount of post-election litigation, that's a good thing. Although I'm not hopeful that we'll see that much less post-election litigation, but maybe we'll see less than if we didn't have the amount of pre-election litigation that we're having. But that invites me to think about another topic entirely, which is the extent to which any of this litigation might or might not affect the presidential election under the Electoral Count Reform Act. And of course, that applies only to the presidential election, and there are plenty of other close races out there this fall. But I know that we've been seeing some concern expressed in various places about the Electoral Count Reform Act and its deadlines and whether states might miss those. And is this a good time to talk about that for a few minutes?
Absolutely.
Sure.
I think it's top of mind for a lot of people as we had, since we're down now just to little over 3 weeks into the election, I think there's a high level of concern that there might be some shortcoming exposed in the electoral count. And so, yeah, I think it is a great topic to discuss. I'm curious to know what everyone thinks about the ECRA.
Well, I think we probably want to have, at least one more, and maybe others, to unpack this new statute. But I think in a brief time that we have left today, I would want to make 2 points. I think some of the public commentary on the ECRA is misunderstanding what it does and is creating worries that are unnecessary. The good news, in my judgment, the very good news about the ECRA is it requires elections, presidential elections, to be conducted pursuant to the rule of law. And that means politicians can't overturn the results just because they don't like them. Not a governor of a state, not the legislature of a state, not even Congress. As long as ECRA is followed and it is the law of the land, then we should get an answer according to what the law requires the answer to be. Your candidate might win, your candidate might lose, but it is the answer that should happen given the rules of the process. There's been some speculation that I've seen that Congress won't follow its own law. I think that's unlikely. The Congress wrote the law, and so I would expect Congress to follow it. It takes both houses of Congress to reject electoral votes under the new law. So even if one house of the Congress decided it didn't like the result, it can't act unilaterally. So I'm not really so worried about that. And I've seen a lot of other commentary that is. What I do think is more top of mind for me is the deadline. That actually isn't new in the ECRA because this deadline comes from the Constitution. The Constitution requires that electors in all states meet on the same day. Congress can pick the day, and the date this year is essentially equivalent to what it would have been 4 years ago, or really any election in our lifetimes. What's new is the sort of affirmation of the statute that yes, this deadline is binding on everybody, including Congress. So to the extent that Tony, you mentioned in Florida in 2000, there was a sense that the state just ran out of time. I hope all states are cognizant of that and don't run out of time this time. If any state does run out of time, it's not the fault of the ECRA. I wouldn't say it's the fact that states haven't figured out how to engineer or organize their procedures to bring an election to closure in the amount of time available. But I like the fact that you're optimistic that, Tony, that's not going to happen. And I want to think more about your optimism. What I was slightly worried maybe that we weren't prepared for as a country is the combination. I mean, the 2000 election was one state was pivotal, Florida, and it was unbelievably close, 537 vote margin of difference, and all of these problems that made it a jump ball or a flip of the coin. And so that was one kind of issue, but there was a willingness on both sides to abide by the rules, whatever the rules were. Gore famously accepted the Supreme Court decision that went against him. Trump was the opposite in the sense that it was absolutely clear that Trump lost, and he refused to accept the loss. And there was all of this litigation that was sort of unnecessary because none of it had any merit whatsoever, given the margins that existed and the rules at the time. So what I don't know if we're prepared for is sort of a combination of those two past precedents in one race, where we've got what we have is something that is like Florida 2000 close, or kind of like that, or Minnesota 2008 close, even though that wasn't a presidential race. So one state, everything hangs on one state, and it's really tight in that state, and there are genuinely things to fight over. And we've got the atmosphere where at least one side, if not both, are unwilling to accept defeat no matter what the the courts say and what the evidence is. That's not a combination that we've seen. And so, that that that's something that could be new if it plays out that way.
And it's worth pointing out, Ned, in contradiction to my optimism, in 2020, one of the advantages for the ultimate resolution of that election dispute was the fact that Biden won by more than 300 electoral votes ultimately, so that no one state had everything riding on it. And as you point out, Ned, certainly Pennsylvania is looming as potentially a state where the whole election could come down to which candidate won. And in fact, today, this is the middle of October, the polls indicate that we're more likely to have an election in which the winner is somewhere around 270 or somewhere in the 270s than that we would have a winner in the 300s. So I would say at the moment, statistically, it's more likely that we could be in a Florida 2000 scenario where one state decides the election, and that then raises the risk that we could have an election decided by just a few hundred votes. And then my natural optimism would abate somewhat because just the stakes are too high. And as you said, we're in an unusual era where we have a candidate in the race who didn't accept the outcome in 2020. In fact, he didn't accept the popular vote in 2016, a race he won in. He still claimed was rigged. So there certainly are all the makings for serious trouble in 2024 if it comes down to one state and the vote in that state is exceedingly close.
Well, I'm going to try to be optimistic. We'll go back and forth on this. I am hopeful that given that the point of the ECRA is to have the rule of law be decisive, and since it was a bipartisan Congress that adopted that measure, I think as bumpy as the ride might be, I think we should go into the process with the expectation that the law will govern. And again, we might like somebody has to win, somebody has to lose, right? One side's going to be upset. And the only way in a democracy you can settle this is either at the ballot with the ballot box according to law, or by brute force. And I don't think the country is prepared to descend into all-out civil war over the outcome of this election. And so I'm optimistic that even that if it's a bumpy ride, that at the end of the day, the law will prevail.
But Ned, of course, one of the things that we have been seeing others claim is that the law, specifically the Electoral Count Reform Act, is ambiguous in a number of ways. And I think you're right to say we need to have another discussion of this in a more detail, maybe next time. We are running close to our time today, but I mean, there's some real misunderstanding, I think, about the Electoral Count Reform Act and its operation that gives rise to people claiming there's more ambiguity in that law than there truly is.
Yeah, I think that's, I mean, I do not think there is serious ambiguity in how the ECRA is supposed to work. There was ambiguity in the predecessor law, the Electoral Count Act, which required it to be reformed. And I don't know that it's right to call it ambiguity, but and Derek Muller wrote a piece on the election law blog today that was very helpful, I thought, on this point, which the ECRA piggybacks on top of state law and requires, again, that everybody follows the law of the relevant state in the appointment of the state's electors, which is done through a popular vote. So you have to count the popular vote properly. So the ECRA, you can't look at the ECRA and know exactly what's going to happen in Pennsylvania or Michigan or Wisconsin, because it's not one size fits all. It just says whatever the rules are in Pennsylvania, everybody's got to play by those rules. So you can sit here today and say, well, I don't know how it's going to play out in Pennsylvania because the ECRA is not telling me that. It's not designed to tell you that. It's designed to require you to look at the law of Pennsylvania to figure out how things go. And back to the point about equal protection, the most ambiguous, frankly, the most ambiguous element of our legal system as applied to the counting of votes is the constitutional doctrine that the Supreme Court created in Bush versus Gore. Now, that may be inevitable because equal protection is a fuzzy term in all areas of constitutional law, right? I mean, equal protection is not self-defining, neither is due process. But it's the fact that the Constitution itself has these generic principles that, are the supreme law of the land. That's creates the most litigation uncertainty, I think, because you just don't know for sure how a federal lawsuit will go if the claim is either counting votes or not counting votes violates equal protection or due process. But how that fits into the ECRA is the ECRA tells us that whatever the federal judiciary decides on any relevant federal issue of federal law is controlling on everybody. Again, governors, state legislatures, Congress itself. So, if there's a genuine issue of federal law, the U.S. Supreme Court is going to be the ultimate authority. And, you may like that idea or not like that idea, but in a legal system, there has to be some final adjudicator. In our system, it's the U.S. Supreme Court.
Well, maybe that's a good place for us to stop for today. There's plenty left to unpack about some details of the ECRA or continue reflecting on what equal protection does or doesn't require in the elections context when they're conducted so locally. But Tony, do you have a trivia answer for us and a new trivia question?
I sure do, Steve. So just as a reminder, everybody, our trivia question last week was, what campaign finance mistake did George Washington make in his rookie campaign for this Virginia House of Burgesses in 1755 that cost him the election? And the answer is he failed to buy alcohol for the voters. In the 1700s, the expectation was that candidates would treat the voters by buying alcohol on election day. Young Washington was kind of a tightwad, refused to do that. And in 1758, when he mounted his second campaign, he learned the lesson from his first. He was actually serving in the French and Indian War. There's a great account here in Ron Chernow's biography of George Washington. And it includes a letter that Washington wrote from the front in Pennsylvania, where the fighting was, back to his campaign manager in Virginia, in which he directs his campaign manager to buy dozens and dozens of gallons of alcohol. And the campaign manager reports that he bought about 160 gallons. It cost about 39 pounds at the time. And Washington's response was, he sent a letter and he said, "My only fear is that you spent with too sparing a hand." But as it turns out, the campaign manager's campaign tactics worked. Washington won. And in W.J. Rohrabaugh's classic book, The Alcoholic Republic, about sort of the social customs associated with alcohol consumption in the 17th and 18th and 19th centuries, he calculates that Washington's expenditure came out to, it was 144 gallons of refreshment, according to Rohrabaugh, how much that Washington bought. He received 307 votes, which was enough to win the 1758 House of Burgesses race. So according to Rohrabaugh, the return on Washington's investment was better than 2 votes per gallon of alcohol. So that's our trivia question answer for last week. And we have a related one for next week. The exact same thing happened to another founding father 20 years later. A very famous founding father, not quite at George Washington's level, but just beneath him. This founder when he ran for the legislature right after American independence, right after the Declaration of Independence, this founding father ran for the legislature in his home state, and he too refused to buy alcohol for the voters. But in his case, it was because he thought it was corrupting, and he believed that the new republic was all about virtue, and candidates shouldn't demean themselves or the electorate by buying alcohol. And of course, what happened? This candidate also lost his first election. So the question is, what other founding father lost his first election because he refused to treat the voters? The answer will be revealed in our next episode.
Thanks, Tony. We'll look forward to that historical trivia reveal next time. It's great to be with you all. See you again soon.
Thanks, everybody.